Thank you, counsel. All right, the court will next call the Whiting versus Whiting case.
Tell them that we're going to have coffee if they want to.
Yeah, we're going to take a break after the second case, just in case counsel from the first case is interested in joining us for coffee.
No, that's okay.
May it please the court.
Sure, yes, sir.
Good morning, Your Honors. My name is Shane Bowdy, and I represent the appellant, Jeff Whiting, in this case. Also with me today is co-counsel Jim Markle. I'd like to reserve 5 minutes for rebuttal, please.
All righty, I got it set.
Counsel, let me ask you, there were competing petitions for administration filed with competing wills. That's correct, isn't it?
Correct.
And there were cross objections. Both sides objected to the other side's petition for administration.
Correct, Your Honor.
At the time the court entered the homestead order, had the court ever determined which petition for administration and which will it was going to determine to be the operative will?
No, absolutely not, and that's part of the issue, is
So
neither one of them.
Isn't the answer to this, laying aside the procedural issues, isn't the substantive answer going to be driven by which will is determined to be the operative will? If it's one will, one side wins, and if it's the other will, the other side wins.
Correct, Your Honor, and tied with that is the trust case as well, because the homestead property was actually in the Lorraine Y. Whiting Trust. And so the will basically turns everything over to the trust, other than a few
Well, and
things.
it's going to relate to whether or not she had the capacity to, but that's all going to relate. It's really going to still come down to the issue of, did she have the capacity to make the changes in, I think it was 2010?
Correct.
And if not, then the 2003 earlier version is the operative one. So
Yes.
I guess if I were to summarize your argument, is it that the court shouldn't have granted this petition for homestead until it determined that initial question?
Absolutely. That's the perfect summary, Your Honor, because not only that,
That's a good argument. I just didn't see that you made that in your brief. Where did you make that argument in your brief?
yes, actually, and because of that and the fact that the trust case, which again, that's the part that's in the argument
Your
in
first
the
point
brief.
on appeal was that she shouldn't have entered the order because she'd recused herself.
Right.
Second point on appeal was that there'd been a stay entered and she should have entered it, right?
Correct.
And the third point of appeal has to do with a novel argument that counsel should just concede that they're wrong because they have an ethical duty to do that,
Correct, Your Honor.
which seems to bear on sanctions rather than the merits. Where did you make the argument that Judge Orfinger just articulated?
I believe, Your Honor, especially in the stay argument, there's a section in the brief that discusses the fact that because the trust case was on stay and because the two competing petitions for administration, and I know that's in the brief, were not determined yet for the will side, that because of those two things combined, at the point where this was determined, the actual trust case was on a stay and on appeal. I think this was done in October, and in December, we had oral argument here that same year. And
What was the difference between the two wills? Are they in the record, the two wills?
the two wills, yes, they're in the record.
Okay, as it relates to whether this property falls into the trust, is there a material difference between the two wills?
The two wills basically, the first will divides everything a third, a third, a third. between the three brothers of, the sons of Lorraine Whiting. The second will, the 2010 will, if you will, the latest one, basically gives everything to the appellant, Jeff Whiting.
But I thought that under the will, the homestead property passed to the trust under the
Correct. So that's the second part of it, is that the homestead property was always in the Lorraine Y. Whiting Trust. It had been placed there years ago. So it wasn't a pour-over will into the trust. The property that we're discussing here was actually in the Lorraine Y. Whiting Trust since in the 90s.
So there's no material difference between the wills as it relates to the homestead property?
As it relates to the homestead, no.
Okay.
As it relates to the trust, which is the other issue there, it is, because again, the trust mirrored the wills.
Well, if the homestead was always in the trust, then what was the jurisdiction of the probate court to enter a homestead determination?
Our argument is none, although it's common practice for the probate judge to make that determination, which is, and we have a case cited in here, it's more of a notice to the creditors that this is homestead. But in the Aronson versus Aronson case, which is cited actually in the appellee's reply brief, homestead determination happens at the date of death. So the trial, or the probate judge, really had no responsibility to determine or to change that determination. All the order determining homestead status is notice, basically, to the creditors that this property, at the date of death, which was in 2011, passed to the heirs.
Are you certain that the homestead was in the trust?
Yes.
So you're saying that there was a deed somewhere that's in the record that conveys this property to the trustee?
Yes, whether it's in the record, but if, I know that in the record is the actual legal description of the property, and the legal description of the property, if you look, is in the Lorraine Y. Whiting Trust. So the property has been in the trust name. Yes. Again, since, I think, early 90s. For a very long time, that has been in the trust property.
So then, as it relates to the trust, if the 2010 revision is effective, it goes to the one son, and if it's not effective, then, and it reverts back to, I think it was the 2003 version, then it goes to the three of them.
Correct. That's exactly correct. And again, that was pending on appeal, oral arguments a month later, when the appellee filed their petition to determine homestead status. And when that was filed, initially, the proposed order, because we had actually had some conversations about that, but the proposed order stated that the homestead property would be devised pursuant to the terms of the trust. No problem with that, because at that point, really whoever won the trust case, if you will, that determination is made at that point in time, just as you mentioned. The problem is that Judge Alley, the trial court judge at the time, didn't accept that order. We didn't object to that order, and I know appellee makes the procedural issue about objection. We wouldn't have objected to that order, but the problem is it got changed to say a third, a third, a third. And that was based on the appellee's contention that at that time, and he writes in his reply
So you're
brief.
saying this proposed order's in the record?
The proposed order is not in the record, Your Honor.
Well, you know what, you're not supposed to come up
Yeah.
here and talk about things that are not.
Yeah, I apologize. You're correct. It is not in the record. However, the one-third, one-third, one-third was based on the status of the cases at that moment in time, which again was on appeal. Had that appeal not been overturned, I mean, had that order, summary judgment, not been overturned, then basically the third, a third, a third would be correct. The problem is it was overturned. The problem is that it's totally not correct now and hasn't been correct since that ruling in the trust case in Whiting versus Whiting 2013 case. So We have basically a roundabout method of achieving a devise in the homestead property through the probate case, which couldn't have happened in the trust
I got to
case.
get you to zero in, if you will, on the issues that you've raised on appeal, okay?
Sure.
So let's just take them one at a time. What's your number one issue on appeal?
My number one issue on appeal is that the judge was disqualified.
Okay.
The cases were companioned in 2013.
Okay, she entered a disqualification order, sua sponte, right?
No, there was a motion.
No motion.
No, there was a motion. There was a motion in the companion trust case for disqualification.
Filed to ask her to disqualify herself.
Correct.
In the trust case,
Correct.
which she
Correct.
granted.
Which she granted, correct.
Okay, now how do we help you with your point there that her entry of that order in the trust case had an effect on the probate case?
So first of all, the cases were companion cases.
What does that mean?
That's a great question, and the appellee makes some argument in his brief regarding that, but there's no case law on the difference between a...
Cases were not consolidated.
Yeah, there's nothing in depending on the motion was for consolidation. What consolidation
Wasn't
versus
granted, though.
companion?
Right, that was not granted.
Well, the motion to...
Consolidation was not granted.
Actually, it was granted, but in fact, the motion says motion to consolidate is granted, but they're companioned.
You mean the order says?
The order says, sorry.
A motion to consolidate is granted?
Yes, Your Honor. And the language used is companioned. In the order, and again, I can tell you my recollection of what happened in that hearing.
If it's in the record, you can.
There is no real distinction between the two. We'll just put it that way. My understanding is there's not a distinction between a companion case and a consolidated case, other than...
Well, I mean, I'll tell you the difference between the two. A consolidated case means the cases are consolidated. They're joined, and they're one case. A companion case just means the two cases are related, and I don't know that you need an order to say that. I mean, they are companion cases because they're related.
Well, and the order states that she reserved the right to, the judge reserved the right to try the two cases together. All the issues are exactly the same.
What are you asking me to write in this opinion? You're asking me to say that when an order is entered in a related case disqualifying the judge, that the judge is not only precluded from entering any orders in that case, but is also precluded from entering orders in any cases where the parties are identical. Is that the
In
rule of law
cases that are consolidated or companioned through an order that the judge knows that there's an order consolidating these
You want to
cases.
say that when a court enters an order saying that these two cases are companion cases, that means they're consolidated?
The distinction I understand is that because one was a probate and one was a civil case, that they don't get consolidated. The word consolidated wasn't used, that the word companion was used. That's the distinction I was understanding.
I'm sympathetic to your
and
plight here, but I'm just
I
trying to understand how you want me to, structure an opinion that announces some legal tenet that makes some sense.
Well, again, I think the way you just stated it would be an appropriate ruling to say...
You can do that. All right, so your second point on appeal has to do with the stay, right?
Correct.
Okay. And this order that was entered, staying a case, again, the problem there is that it only stayed the trust case, right?
Well, again, these orders were drafted by the judge, and there were two orders given at that moment in time. One of them has both case numbers on there. The other has two case numbers on there. They happen to be the same case number, which is the trust case. The problem is that doesn't even make logical sense, that obviously, because the cases were companioned, And because the judge understood that rulings in one affect the other, and that the trust case was now on appeal, that both cases were to be stayed. And the error in drafting the order, which did only put the one case number twice, shouldn't overcome that substantive issue.
And if you had gone back to Judge Alley and said, what did you mean here? And we'd have gotten some ruling out of her on it. I mean, we're an error-correcting court.
Sure. Sure.
You have to show us, where you asked for something from this judge or objected to something from this judge that, she did that is an error by her. She hadn't even been alerted to, apparently she hadn't even been alerted to the fact that this stay order only had one case number on it. We don't know what she was thinking at the time.
Yeah, we don't have any idea what she was thinking, I would agree. We did file the motion for reconsideration.
Of the fact that your client filed an untimely objection to the petition that is at issue here.
Again, I don't think that there is really any effect, because based on the case law that we've cited, a disqualified judge or when a stay is in process, all of those rulings are void anyway. So that's what we would ask this court to look at, is to say that that ruling was made when she was disqualified and when there was a stay in the case.
But aside from the disqualification issue and the stay issue, if you didn't have those issues to argue, from a merits standpoint, is the fact that you didn't file a timely objection to their petition. I mean, isn't that a waiver of, does the judge commit error to grant the petition in the face of no timely filed objection?
That's a great question, and I don't know how the best way to answer that, other than to say, at the time, that was not the issue that we were concerned with, and that's why no objection was filed. When we discovered that issue, that's when we immediately filed a motion for reconsideration, and then had to file this on appeal because of the timing issue. At that point in time, we tried to bring the issues in front of Judge Ali on the motion for reconsideration, which is in the record, to say, hey, you were disqualified from the companion case, there's a stay in both cases, why did you make this ruling, and please change it at that time.
And that is in the form of your motion
For reconsideration.
vacate, which you never
Yes.
had heard, right?
That is correct. That's correct, Your Honor. I see I'm running low on time
Down to
here.
about 3.5 minutes.
Is-
Want to save it for rebuttal?
Yes, thank you very much.
Okay.
Good morning, may it please the court. I'm Francis C. Pierce III. I represent Anthony Whiting in this matter. We believe that the order on the homestead should be affirmed by this court because there was no timely response to the petition, and at that point, the
Well,
court...
was this property in the trust?
That's not in the record. The deed is not in the record. So, again, I don't want to make reference to...
I mean, because if there is a deed and it puts the property in a trust, it doesn't make any difference what order the judge entered in the probate proceeding, right?
Well, the issue is, for homestead, you really can't hide assets in a trust to keep them away from creditors. So there's a pour-over...
But we're talking about two different things. There's a difference between homestead and its action on creditors.
Yes, sir.
And homestead for purposes of devise. I mean, I think that y'all are talking about the issue of, was this a devisable homestead? But, I mean, the bottom line, as I understand it, is if the probate court has jurisdiction to determine matters that relate to the decedent's estate, and that there's at least one case out of our court called Ford versus Ford that says if homestead is in a trust, it's not in the estate, and the court doesn't have any jurisdiction to do anything with it. So even without an answer to the question about which trust is the operative trust, I guess I still come back to the question of what jurisdiction did the court, I mean, if there's really a dispute, I suppose, over whether the property's in the estate or not, maybe what we have to do is remand it for the court to determine whether the property, the homestead property was an asset of the estate or an asset of the trust, whichever version of the trust is in effect. But if there's no dispute that it's an asset of the trust, what jurisdiction does the probate court have to do anything with it?
The issue is to determine whether the property first is or is not homestead. That's the first decision that has to be made. Was it?
Can only affect assets that are part of a decedent's estate. It isn't an asset of the decedent's estate if it's held in a trust. I mean, let me just read to you from a case out of our court, 1991, called Ford versus Ford, and it was basically the same situation you've got here. And we said that if there's no real property in the estate, then there is no authority for the probate court to determine homestead property. And that the interested person who can petition for a homestead determination under Rule 5.405 can only do it as it relates to homestead real property owned by the decedent. And we go on to say, because this property was in a trust, it wasn't owned by the decedent, so it was never in the estate. I'm just trying to understand why this just isn't some advisory opinion from the judge.
I think that the issue is, first of all, whether that property can be an asset of the estate subject to claims of creditors, because there's two different concepts. First, is it protected homestead that creditors have no claim on, versus the second question of whether it's divisible as homestead property. And I think those are the two issues. I don't have the probate practice as a part of my armamentarium so that in a day-to-day basis, I draft wills and
Well,
probate
this order
them.
did both things, right? Didn't it?
I'm sorry.
This order that is on appeal
Yes, sir.
did both of those issues, took care of both those things.
Yes, sir. And so,
So it purported to devise this property to the three heirs rather than to the one heir, right?
it determined first that the property was homestead, and secondly, how it was to be managed.
How can, I mean, back to Judge Orfinger's question, how can the probate judge do that?
I believe that the probate court does have the jurisdiction to make that determination of whether or not it
Not if
meets.
the property is in the name of the trust. So, I mean, do we have to relinquish it back for that because it's outside the record and we don't know? Is that?
Again, and that could have been raised in a timely.
Jurisdiction is jurisdiction now.
But even your petition that you didn't file it, Mr. Chong, I guess, filed it.
Yes, sir.
Says, the decedent owned a beneficial interest and resided on the property described as so-and-so. The decedent's trust contained a provision allowing her to retain a possessory interest and upon her death devise the property to her heirs at law, A, B, and C. So, I mean, it seems pretty obvious to me that even this petition recognized that it was in the trust, that at best she had a beneficial interest in it as a beneficiary of the trustee. She had perhaps an equitable title, but not the legal title.
And it seems to me, Your Honor, that this issue could have or should have been raised at the time that the petition was filed within the.
That jurisdiction, what jurisdiction does the probate court have to deal with assets that are not part of the probate estate?
Again, I'm being pulled towards trying to identify the transfer, if there is one, outside the record in terms of how that property was held.
Well,
And it's,
I just read to you your client's petition for
Yes, sir.
a homestead determination, which suggests strongly to me that they recognize that it was in the trust. Let's assume, for the sake of my discussion, it's in the trust. The title of the property is in the name of, you know, the Lorraine Whiting Revocable Trust.
Yes, sir.
And so if we make that assumption for the sake of my question, what jurisdiction does the probate court have to do anything with it?
I have not thought that issue through because it hasn't been an issue that was argued. I mean, I can kind of do it on the fly, but I don't want to make representations on a case I haven't read to prepare for this oral argument on an issue that hasn't been raised on the oral argument, and jurisdiction wasn't raised in the appeal. So that in that circumstance.
Right. And you're right about that. But let's talk about the issues that were raised on appeal. Let's take his number one issue. Why would the judge enter a recusal order in the trust case and not similarly recuse in a probate case involving all of the same parties?
I don't know why she would have done one versus the other than the proceeding in which the request was made and the case number.
Did the motion have both case numbers on it?
That's not in the record, Your Honor.
Motion to recuse is not in the record.
Not in the record.
Well, I'll tell you what, you guys just can't, throw all this at us and expect us to figure it all out when you don't give us what we need. I mean, that's not really a fair way to do this. All right, the order, though, of recusals in the record.
The order of the recusals in the record
It has two case numbers on it, but they're redundant. They're stated a little differently, but the identical case. Why would the order have essentially repeat the same case number with a conjunction "and" on it?
Your Honor, I could speculate that whoever was drafting the order to cut and paste didn't do a very good job of it.
Right. And that the judge really intended, why would the judge not recuse? I mean, as a matter of the law, if the judge found a basis to recuse in the trust case, then presumably she has to recuse in the probate case too, right?
I'm not sure I would agree with that because the issues between probate and trust are, while they may be similar issues to the parties, there's a lot of differences between what's going on the civil side and what's going on the probate side.
Recusal's not based on what the issues are. Recusal's based on who the litigants are. I mean, or whether there's some bias on part of the trial.
Well, if we look at the order that the appellant attached as Exhibit B to their initial brief, it says that if the parties want any of these documents to be considered in both cases, they have to be dual styled and dual numbered with the earliest number first, and that wasn't done on the order of recusal. And so there is no evidence that Judge Alley recused herself in the probate matter.
What is the address of the property that we're...
I
mean, on the notice, I didn't know if you had the address of the property.
I don't have it committed to memory, Your Honor.
I'm looking at a certification of trust on page 60 of the record, which references property at 240 First Street in Geneva. Is that the address of the property?
I can't tell you that, Your Honor. I haven't committed that.
That property, it says this property and it's ex non-homestead.
I think that there was a side issue. There are a number of parcels involved, and one of the issues was whether that parcel was or wasn't homestead, and I think the point of filing that document was to demonstrate that that specifically says on the face of the deed, this is not homestead. So I think that on the issue of whether or not Judge Alley recused herself, there's no order of recusal in this record. And similarly, there is no order of stay in the probate side. And so...
And the orders, the stay order had only one case number on it,
That's correct, Your Honor.
trust case?
And it was not a probate case.
And was that predicated upon a motion, or was that done sua sponte?
I don't think that's in this record, in terms
Or
of,
whether there was a motion to stay in the record?
that's on the trust side, and,
Yeah.
again, not part of this record, and
Being asked here, you know, in 2 points on appeal to interpret these orders, and we're being asked to do it in the blind, basically, without giving us the motions or something to give us some backdrop, and that may not be your responsibility, but it is frustrating for the court.
And again, maybe the answer to that is, there was no timely motion filed, and when the objection was filed, those two issues were not part of the objection. It wasn't until, I think, 10 days later that the verified motion to vacate raised those issues for the first time.
What did the objection say? What was the substance of it?
The objection questioned the nature of the devise and suggested that there was a lapse provision on the deceased brother. There were 3 brothers, and that the property shouldn't be divided a third, a third, a third. It ought to be divided 50-50 between the appellee and the appellant here. So in the objection, there was no issue raised that the judge didn't have any authority, and there was no issue raised that there was a stay. The objection says, instead of doing it 33%, let's do it 50%.
So the deceased brother would have been left out, the deceased brother's heirs, right?
Correct, and so
Suggested, right, okay.
that was the argument that no one ever got a chance to deal with, because there was no motion for extension, there was no attempt to set it for a hearing, so it was untimely, and the court had the authority under Rule 5.040 to rule on the motion as she did. And so, in the absence of any record of stay, in the absence of any record of disqualification, and in the absence of a timely response, we believe that this order should be affirmed. Unless there's any other questions.
Anything else, Judge Wilkins? No. Judge Berger? Okay, thank you, counsel.
All right, thank you very much, Your Honors.
Just one quick thing, Your Honors. In the case of Goolsby versus State, this court stated that even when there is no request for recusal and no order on recusal, that the judge's own language happened to be in that order, that a different order that she had written, can be used as a recusal in the case. In that case, the judge had basically written in an order that it was inappropriate for her to consider the matter, but when it came back around, she actually heard the issue and made a ruling, and this court basically said that, you know, even though there was no formal recusal had occurred, that the language that she had was effective as a recusal. So in the instant case, which I think is even a little more egregious than that, we have companion cases which there is an order of disqualification on. I don't think it's a stretch to be able to say that
Well, there's
the judge is...
an order in one of the cases,
Yes,
right?
correct.
And is counsel correct that the motion to recuse is not part of the record on appeal that we have here?
The motion to recuse is not part of the record, and the issue there is...
Why isn't it part of the record?
Thank you for asking. We did file a motion with this court to use the trust case record, which all of that would have been in, which was denied.
Okay.
So
that
unfortunately,
wasn't
yes,
done by-
it would have helped.
That wasn't done by, that order was not done by the 3 of us.
Yeah.
You know, that was
I
before the
understand.
case was assigned that you filed that
Yeah, I understand.
motion, and it was done by a motion panel, and we'll have to look at that, because that may have been an error by us, too.
Yeah, because there was a lot of stuff like you have been asking that would have been in the record with that case, unfortunately.
The reason that the clerk did not send it up as part of the record routinely is because it had a different case number on it.
Absolutely. Absolutely, which is true. You did ask a question about the order staying proceedings, whether it had one case number or not, and obviously that is in the record as attached to the reply brief, which it does have two numbers on there. This is the repeating numbers. So the order staying the proceedings has the two case numbers, which are identical, basically.
Yeah, but it just says that they're going to be companion cases. It says if you have to if you file anything that you want considered in both cases, you got to put both case numbers on it, right?
That's in the motion to consolidate. This is the actual order staying the
that's the
proceedings.
stay order.
Yeah, this is the stay order, so.
And it has both case numbers on it?
It has two case numbers that are both the trust case number. So, any other questions? I do have the address of the property. It's, real quick. I just had it. Sorry, apologize. It's the Cemetery Road, 502 Cemetery Road, Geneva. Thank you.
All right, thank you, counsel. We're going to take a brief mid-morning recess.